Thank you very much for the kind presentation. And well, and yes, you know, during such an event, being the last to speak is a special responsibility. Well, if we imagine today's program as a kind of a restaurant menu, this is meant to be the dessert, so to say. And of course, torture is the perfect topic for that, isn't it? I am very lucky also to be speaking after Judge Yüksel, because I think she has covered very extensively one of the aspects of Article 3, and perhaps that the aspect that I wasn't going to cover anyway. So that's already very helpful in terms of the completeness of the picture, so to say. Well, the reason why I suggested that I might speak about this particular topic, even though, of course, each of us can cover various topics, was partially due to my background, which I share with my friend, colleague, and I would say my teacher, my professor, Judge Husseinov. We both have the experience of serving on the European Committee for the Prevention of Torture, both of us for the full term of 12 years, both of us as presidents of that committee, with the common experience of 10 years. So, in a way, you will understand that this is something that is rather close to my heart, but also this is something that I had an opportunity to deal with from a perspective which is quite different from that of the court, even though it was based entirely on the European Convention on Human Rights and the experience and the case law of the court. And which is why, of course, when I joined the court three years ago, more or less, it was very interesting to see this through the sort of the perspective, from the perspective of a judge. And I must say this perspective is quite different. So part of my learning about the profession, about being a judge at the court, was also trying to put up with the approach that the court has developed to Article 3, which is much broader than that, the one I had prior to joining the court. Well, and now I think 3 years after, I can't say that I have found answers to all the numerous questions I had when joining the court, but I am moving in that direction, in the sense that I'm looking for those answers, and perhaps I'm trying to find where the answers might lie, even if I'm not entirely sure what they will be like. Anyway, enough of this kind of more cryptic hints, and I would simply say that the title is also not accidental, in the sense that it emphasizes the absolute prohibition of torture and other forms of ill treatment under the Convention, which is something that I must say gave, on the one hand, it in a way gave rise to the way the Convention has been interpreted by the court, because essentially the case law, the Article 3 case law, is very much behind the more general concept of the living instrument, starting, of course, with Tyra versus the United Kingdom. I'll continue also quoting, of course, cases against the United Kingdom. United Kingdom being the country which is generally has the lowest per capita rate of applications against at our court. But nevertheless, the cases, and perhaps for that very reason, the cases against the United Kingdom are so important for the development of the court's jurisprudence. But at the same time, one wonders how the current state of thinking about the Convention is actually compliant, or how does it sit with the Article 3 case law, and anyway with the initial meaning of Article 3 in the Convention. My intention today is to talk a little bit about what it actually means, the absolute prohibition, how far it extends, how absolute is absolute prohibition from the point of view of the court, and at the same time to see whether the more modern concepts, such as shared responsibility, that Judge Pazzolai was discussing this morning so eloquently and with such a great sense of humor, which is probably the only way to approach this concept, is rather intriguing for me. So I was trying to look for some answers there. And I will also try to use the time generously allocated to us, to each of us by the organizers, without, again, in any way delaying our dinner, to perhaps discuss a little bit more in depth at least two major strands, or well, if I really have time, even three major strands of the case law under Article 3, namely the applicability of Article 3 and the suitability of Article 3 to deal with issues of a systemic nature, such as bad conditions in prisons, overcrowding and so forth, such as structural issues with the effectiveness of investigations, and possibly also I might touch upon the question of the burden of proof, and again the question of how the court approaches the interplay between procedural and substantive aspects of Article 3. But we shall see how it goes again, and I will try to keep an eye contact with you to make sure that more than at least let's say more than 30% of the people present in the audience stay awake. And if that is the case, I will certainly continue. If not, I will probably have to stop. Let's start with the absolute nature of Article 3. Well, Article 3 is, of course, as everyone knows, is a very peculiar article because it's in the first section, in the first chapter of the Convention, it's the shortest article. The idea that no one shall be subjected to torture or inhuman or degrading treatment or punishment is set out in Article 3 very succinctly. There's no second paragraph in the article. There are no interests competing with the prohibition of torture and other forms of ill treatment. The court, accordingly, is not called to make any balancing act, which is, of course, such a famous type of intellectual exercise that the court is engaged in. So there is nothing to, no competing interests can actually justify a violation of the absolute prohibition. So it is absolute. But having said that, we also know, and I will not be taking you through the textbook or the case law guide on Article 3 on our wonderful knowledge sharing platform, which I'm sure everyone is actively using, to say that, in fact, it's long established that in addition to the absolute prohibition, in addition to the negative obligation, that is the absolute prohibition of torture and other forms of ill treatment, we also have positive obligations. That is, certain measures that the state should take in order to prevent torture and other forms of ill treatment, such as establishing the legal framework, sometimes taking certain organizational measures for certain peculiar events where there might be such a risk. Then, of course, there's the procedural obligation to carry out an effective investigation into alleged ill treatment, which the court extended from just the case, first to cases where there's an allegation of an ill treatment by a state agent, and then even to ill treatment by private parties. And you have just benefited from the very comprehensive and absolutely superb analysis of the domestic violence part of our case law, where this is the case, because it is about ill treatment by private parties. And there, one might wonder, are there no competing interests? Are there no justifications for being a bit more sort of lax with that kind of obligations on the part of the state? And that is, that's a question that I don't think has such a clear and direct answer, because the court will not be analyzing lack of compliance with positive obligations under Article 3, in relation to, some other interest that might be preventing the state from doing so. Also, let's not forget that the absolute nature also manifests, of Article 3 also manifests itself in the fact that it's a non-derogable article. So, Article 50, there can't possibly be a situation where under Article 15 a state might derogate from obligations under Article 3. So, but then when the court actually assesses all these obligations except the negative one, it has to take into account various factors. The court would be saying on certain occasions that there shouldn't be excessive burden on the state, let's say in anticipating and preventing private acts of ill treatment. That's the whole logic of, notably Kurt now, as Judge Yüksel was explaining. Then the court would be carrying out an overall assessment of how effective the investigation has been, and the fact that certain criteria that the court has developed over decades in its case law concerning the effective nature of the investigation, they might not be met or might not be met so well. So it's also a question of assessment. And then overall, the investigation would still be compliant with what is expected of the state. So here, obviously, we have the field which I don't think has been so well explained by the court in the sense that the analysis is left to the professors and of course to the academia, and there are excellent academics dealing precisely with Article 3 and the absolute nature. I can immediately recall at least, I think, 2 recent monographs, very, very strong monographs on this. I think one is Professor, if memory serves, Professor Stoyanova, and the other is Professor Mavri Nicola. So these are excellent studies, but this is not something that you would directly see in the case law of the court. Of course, no one would seriously question the absolute nature of the negative obligation. I'm sure, in this room there wouldn't be anyone who has never heard about an attempt to attack the absolute nature of the negative prohibition by putting forward the ticking bomb scenario, for example, or invoking victims' rights and things like this. But obviously, these kind of approaches, they have been refuted by the court. They have been refuted also academically for various reasons. But well, for example, one of the lines of our case law that is a very interesting one, and which we have informally discussed already during this excellent gathering quite recently is the notion of the right to hope and the prohibition of the irreducible life sentence, which can be attacked from the point of view of the victims' rights of the victims of a certain crime. But of course, that is plain wrong, because I think it's axiomatic that human rights are inherent, they are universal, they are not granted on the basis of merit or on the basis of someone's behavior. So obviously, the protection of such a fundamental norm cannot be withdrawn simply on the basis of someone's actions, because this is fundamentally against the concept of human rights and of the universality of human rights. And I think that this is something where, regardless of how far other parts of the case law are going to be developed, this is something where the court must remain steadfast, so to say, must not move an inch, because human dignity is the key to the entire system, is the key to the convention, is the key European value, is the key value that has to be protected at all costs. And I would like also to draw your attention, to remind you, of course, something that you also know very well, that the court has reiterated on so many occasions that Articles 2 and 3 of the Convention, the right to life and the prohibition of torture, these are fundamental values of a democratic society. And at first, when I read this, when I was a student and I read this the first time, I was a bit surprised. What does it have to do with democracy? Democratic freedoms, they are in Article 8, 9, 10, 11, so on. There are balancing acts there. There are extensive provisions on how you can interfere with those rights for a good reason, necessary in democratic society, and so forth. But all of those democratic freedoms are, well, they're worth nothing without the protection of the life and dignity of an individual. And we see now with the so-called democratic backsliding, let alone with armed conflicts, with the wars, that it all, of course, it all very well starts with curtailing democratic freedoms, but then ultimately it's about the neglect of an individual. It's, I mean, the most repulsive acts and policies that can be observed nowadays in Europe every single day, they are based on a complete disregard of the value of an individual human life and on individual dignity. So I think there it starts. When this respect is missing, well, the system is not going to hold. That is quite clear. So on that, one needs to be very, very strong and principled. Now, along these lines, I would like also to reflect a little bit about the applicability of the most fashionable, I would say, concepts in the court's case law, in the discussion and in the discussions around the court that we have had for a while, at least, well, of course, it was way before the famous article by then Judge Spano about the age of subsidiarity was published, to what Judge Pazzolai referred today. But of course, this is something that is very much present and is very important in understanding the role of the court in recent years, in particular with the explicit inclusion of the notions of margin of appreciation and subsidiarity into the preamble of the convention, with the entry into force of Protocol 15. I was wondering, do they actually apply everywhere to each right, and in particular, would these notions, would these concepts be applicable at all to Article 3? And, well, Article 2, for that matter, I think the analysis would be very, very similar. My current thinking, and again, I invite you to think about this, and it's, of course, absolutely fine if you disagree with me, and I would actually welcome any discussion in this respect. I think this is this is the field where a thorough discussion is necessary. So my current thinking is that they actually do apply, but they apply very, very differently compared to other provisions of the Convention. Let's start from the basics. The basics, I would say, the first concept, I think the mother of everything else, would be the margin of appreciation. Well, you can say subsidiarity, but okay, let's say margin of appreciation. Well, generally speaking, this doctrine allows the court to grant national authorities a certain degree of discretion in how they implement convention rights. So they recognize, this recognizes that the domestic institutions are generally better placed than the European Court of Human Rights to assess local needs and conditions, especially regarding morals, social policy, or allocation of public resources. And then, of course, the court has employed and employs every now and then the concept of the margin of appreciation, characterizing it as wide, less wide, a certain margin of appreciation. Well, ultimately there would be a narrow or even a very narrow margin of appreciation, depending, of course, on the case law. But is there a margin of appreciation when it comes to Article 3? Well, I think on the standard, on the negative prohibition, there is none. I mean, this notion is perhaps not applicable for obvious reasons. No exceptions, no balancing, no competing interests, nothing to discuss in a way. Well, so this is universal, this is objective. However, when it comes to positive obligations, then there will already be at least a certain margin of appreciation. And sometimes, depending on what we're talking about, this margin of appreciation can be wide enough. For example, how exactly the state deals with its penal policy to prevent violations of Article 3 on account of bad material conditions in prison is very much in the hands of the state. You can change the penal policy, you can simply sentence less people to a prison term, or to shorten the sentences. That's one way of dealing with this. There's another way of dealing with this: build more prisons. And there's everything in between, so to say. So basically, there's probation, there's other types of alternative measures. Really, it's very much based on how the state sees it. And of course, here also sort of the democratic considerations they kick in, because I think the penal policy is a matter for the parliament, and the parliament will be guided by the choice of the voters. And the experience of many decades has shown that one of the simplest and most straightforward ways of ensuring a better result at parliamentary elections would be to promise to be tougher on crime. Well, that necessitates perhaps expanding the prison estate or renovating it, and So positive obligations that can work. So basically, margin of appreciation, we have no margin for the negative obligation, and we do have some margin on the positive obligation. For the procedural obligation, for the obligation of effective investigation, again, the systems can be very different. There isn't one single system which is efficient. Something that Judge Huseynov and I dealt with extensively during our time in the CPT, in the Committee Against Torture, was the question of the establishing an independent police complaints body in a country. There are different models there. Of course, most neutral experts, so to say, would favor the approach in the United Kingdom with having an independent authority. Well, and the approach that also exists in some Nordic countries, such as Norway, for example. Whereas in Eastern Europe, in the former socialist camp, so to say, there would still be powers vested in the prosecutor's office. And well, it's impossible to say immediately that the relying on the prosecutor's office is destined to fail. It can be an option to deal with the issue. It depends on the state, really. Now, subsidiarity. Well, here I think we heard it today. I think Judge Chanturia made it very clear in his presentation today that, of course, the court needs the domestic authorities. We all need the domestic authorities. The convention is based on the presumption, well, that the domestic authorities operate in good faith, that they are committed to ensuring and protecting human rights and fundamental freedoms. So, of course, it's for the domestic authorities not to torture, not to ill-treat, but also to prevent any such instances. Also, Article 3, as absolute as it is, does not free an applicant from the general obligation to exhaust domestic remedies. Certainly, if a remedy has proven to be ineffective, then of course applicants go directly to the court, which creates another huge issue to the court. I will come back to that. But occasionally, and that is particularly acute in the Article 3 type of cases, the European Court of Human Rights is forced to act as a court of first instance, and it is put in a very awkward position, I would say, systemically. And it has to act, it has to react to this. So anyway, here's this kind of subsidiarity is certainly there. However, the level of deference to the domestic authorities that the court should demonstrate in Article 3 cases is by far lower than for Article 3 cases than for, let's say, Article 8 cases. At least some, at least most of them. It really depends, because Article 8 is, of course, the field of application is fairly broad. So if the court finds, or there are reasons to find, that the treatment reached this threshold of applicability of Article 3, when Article 3 is at stake, the court, and I think this is what the case law confirms, and this is my strong conviction, the court must not defer to a contrary finding by domestic courts simply because they are better placed, so to say, or they were the first to assess the facts. So here, in Article 3 cases, the supervisory role of the court must be particularly rigorous. So, in other words, subsidiarity does apply, but it applies structurally. It doesn't, in terms of the primary national responsibility, the exhaustion of domestic remedies and so on. But the way that the court should rely on the domestic judgments is much weaker for Article 3. Now the shared responsibility. Well, the shared responsibility, at least for now, is a slightly more sort of is a slightly vaguer concept, as we could have also ascertained from today's lecture by Judge Patsolai, compared to the first two, to subsidiarity and margin of appreciation. It would really depend on the circumstances of the case, but in any event, the absolute nature of the prohibition imposes rather stringent obligations on the state. And that works in such areas as the non-refoulement, the sort of soaring line of case law. So the descending state will be held responsible under Article 3, even if the potential ill treatment will occur elsewhere. So there's responsibility then for tied to the control of the descending state over the question of the departure of the individual. There has been case law concerning the multi-state or international operations, such as Al-Jeddah, for example, Al-Skeinik type scenarios, where the states are acting abroad jointly, but still they retain their obligation when acting jointly or extraterritorially, well, provided, of course, that the court finds jurisdiction, and which is a totally different matter. But other considerations concerning shared responsibility, I think, essentially replicate those that I have just tried to set out when talking about subsidiarity. So basically, this is, in a way, this is rather synonymous. Now, also a little bit about the terminology used and the development, and again, in the light of the development of the case law. Back in 1978, in the interstate case of Ireland versus the United Kingdom, the distinction was made between torture and inhuman treatment. And the court has, well, regardless of how correct from today's point of view this distinction was, the court said something very important, that the notion of torture should attach a special stigma to deliberate inhuman treatment causing very serious and cruel suffering. Well, this stigma thing I think, is something that we need to retain, because even if torture is put in one package with inhuman or degrading treatment or punishment, the special stigma applies to torture. Again, people who have been involved in the, if I may call it so, the anti-torture business, know that sometimes torture is described as the T word. That is the sort of the word that you should be very careful pronouncing very carefully. You think twice before you pronounce it, because it stirs serious emotion. Certainly not during the second day of long lectures, but in principle, when people are accused of having tortured, or they say that somebody has been tortured, this does stir emotion. We've had this experience, again, Josh Hussein and I, when talking to different authorities, ministers, heads of government, whatever, in various European states, when we speak about the allegations of torture, not of ill treatment, but of torture, then there's always reaction. This is meant to be a serious allegation, so to say. This is a serious accusation. So the whole notion must include a threshold. It cannot function without this threshold. You can't call everything torture. When you do that, you basically really devalorizing this. It's something that is completely becomes completely trivial, and that's one of the also key ideas and key things that keep haunting me also when I'm thinking about our case law. I'm generally very anxious about avoiding the overstretching of Article 3, and in particular of some of the key notions, including torture. That I think is something that is necessary, because avoiding this is necessary for reasons that I think they must be quite obvious to you. this is something that should not become subject of, to inflation and banalizing torture, banalizing even other forms of ill treatment I think is very wrong. It's always a big deal. It's always a big deal in my view. So it's always serious. So anyway, in the case law, we have a rather high threshold in Ireland versus the UK. We have this threshold significantly lowered in 1999 in Salmoni versus France, where the court explains, and if you haven't, for some reason, haven't read that judgment and you're interested in the Article 3 case law, I would very much recommend that you do so, because I think there we can find the best explanation of the development and of this case law and of the fact that what might not have been considered torture some time ago is considered torture now, and also that the individual factors should be taken into account. And that is, but that in itself also, I probably in parentheses, I must also say that, well, yeah, but we are talking about something absolute. There's absolute prohibition, but absolute prohibition of something that will only become this thing, the absolutely prohibited thing, depending on the individual characteristics of the victim, so to say. So basically, well, in primitive terms, the kind of treatment which is given to a, like, to the person, the average profile you can find in a prison, a fairly strong man in his 20s, would be different from the treatment, what you would call torture in that case might differ from what you would call torture in the treatment of a frail old person, let's say. So obviously there are certain things there, but Salmoni is still very, very important, and this is basically the mother judgment of the whole strand of case law concerning police ill treatment, the systemic police ill treatment. So this is the judgment that really shaped the case law of the court regarding police ill treatment, regarding the absolute prohibition. Then again, I'm making huge leaps, of course, because again, as I said, I'm not going to take you through the whole evolution. Another major addition to the case law happened in 2015 when the Grand Chamber delivered its judgment in Bouygues versus Belgium. And there we have the notion of degrading treatment, which is developed, which is formulated the way that it is currently understood. And just in a nutshell, again, on our wonderful knowledge-sharing platform, which I invite you to use again, you can find even a special document which deals just with the Bouygues judgment and the consequences of the Bouygues judgment. So I think it's super useful. I'm not always comfortable with the contents, but it doesn't matter. This is what the case law is now. And there, basically, the court disposes with the threshold of severity for degrading treatment in situations where the victim is either let's say, at a police station, like Mr. Bouygues was, under the control of state agents, or, and there is a slightly troubling phrase there, or more generally is confronted with police officers. Well, I think one needs to be very careful with what it really means, confronted. So any use of force against this person, which is not strictly necessary, can be construed as degrading treatment. Well, in the case of Mr. Bouygues, it was a slap at a police station. Well, I think the scenario of somebody being slapped at a police station and slap considered a degrading treatment is correct. I mean, don't get me wrong. I think that part works perfectly. I'm not so sure how it exactly should be interpreted in context outside of that. And again, in this nice case law analysis, analysis of the post-Bouygues case law, you will see that there have been different contexts where the court employed this idea. But essentially, it doesn't matter whether there has been any grave consequences for the victim, any particular suffering, except that it was humiliating. But then it also doesn't always matter that there might have been no intention to humiliate the person. And that is, again, an interesting subject. It doesn't mean, so the court looks into the question whether there has been intent or not, but it's not decisive. But again, this is something that one has to be rather careful about. So anyway, the line of case law about the policial treatment is, I think, with Salmouni and then Bouygues is fairly good on the negative part of it, on the negative obligation. Now, on the procedural obligation, we have, of course, the whole, again, incredibly long and detailed line of case law. Perhaps Asenov and others versus Bulgaria would be the, well, it's not the starting point, but this would be the judgment that explains very well how the court conceived this. It's a 1998 judgment, so it's fairly old. And then there came also the idea that is very present in the case law today, and this is the question of presumptions. And I will not deal with it separately, but simply to say that when a person is under control of the state agents, well, typically at a law enforcement agency and typically at a police station, then it's up to the state to explain what might have happened to the person who, I'll take the primitive scenario, enters the police station without injuries and exits with injuries. Then it's for the state to explain what happened. Procedurally, then it led to a further presumption, which is a bit more developed, a bit more stretched, but is still necessary from the point of view of the court, namely that when not the person, but the facts are exclusively within the knowledge of the state, and there hasn't been investigation that shed light on those facts, and they haven't been established in the way that would make the court believe that the investigation has been carried out properly, then again there will be a presumption in favor of the applicant, so the court will, or might, it doesn't say it will, it says the court may draw inferences. So the court may, and it often would do so. And but this procedural type of case law, I don't want to go very far there, also for the reason that it's a kind of shared case law between Article 3 and Article 2, and then with Article 4 nowadays. So it's basically this whole effective investigation and the presumption and so on. This is, I would say, a topic that merits a separate examination, but still is part of our Article 3 case law. And I think, looking at the clock, I think finally, as I promised, I will develop a little bit the thinking about the conditions of detention line of case law, and I'll probably leave it there, and then we would be able to discuss a little bit, or I'll answer the questions that have been prepared for me. So the conditions of detention, the current line of the conditions of detention case law is essentially as old as the one on the modern concept of policial treatment, so to say. Because I think it would be fair to say that this line of case law is more or less exactly 25 years old. starting with Kudwa versus Poland, where the court actually didn't find violation on account of material conditions, but the court said that a state must ensure that a person is detained in conditions which are compatible with respect for human dignity, that the manner and method of the execution of the measure do not subject him or her to distress or hardship of an intensity exceeding the unavoidable level of suffering inherent in detention, and that, given the practical demands of imprisonment, his or her health and well-being are adequately secured. So basically the idea that somebody can be ill-treated, that is, Article 3 can be violated on account of material conditions in prison. There is also a subsidiary line of case law regarding the health care in prison and the quality of medical care and so on. We'll not go there now, but I mean it's also one of the strands in its own right, of course. So the idea is there, but then how do you measure that? This is again where Judge Huseynov's and my practical experience comes into play, because that's exactly what we've been doing. First him, then we a little bit together, then me, namely trying to understand what are the conditions that could be problematic from the point of view of Article 3 by going to prisons and seeing what it meant in practice. And for the court, this task has proven to be quite difficult, I must say, because these criteria, they are very, very much dependent on the case. So I think the best assessment, I'm quite convinced, the best assessment can be made only on a case-by-case basis. You really, to make sure that there is a problem under Article 3, you really need to see those conditions. You really need to evaluate how they affected the situation of a concrete prisoner. But we are talking about hundreds of thousands of people in Europe. You cannot possibly assess each and every case. Being an international organization or international court, even more so. There must be some objective criteria, but where to take them from? Well, the court tried to come up with something. One of the important judgments here would be Ananyev versus others versus Russia in 2012. But still there was a lot of uncertainty also about the applicability of those criteria at the pan-European level. So finally, a case reached the Grand Chamber to answer those questions. It was a case against Croatia, Mursic versus Croatia. And well, as is often the case, you know, with the court, a systemic issue is dealt with on an example of a country which would not necessarily be the worst in the group, or sometimes quite on the contrary. But anyway, Mursic versus Croatia was the case, and it remains the foundation now of the court's case law, of the standards that exist in the matters of conditions of detention. In the CPT, we tried to help. The judgment of the Grand Chamber in Mursic was delivered in 2016, and in December 2015, not accidentally, the CPT published its sort of compendium of its standards on assessing the conditions of detention, but simply to help the court, notably concentrating on the question that was before the court, namely the living space per prisoner. And the CPT has set out its views about the living space, the conservative standard that was, by the way, developed absolutely empirically. So there is no science behind this. It's simply the experience of visiting prisons and seeing how they actually function in Europe. That the CPT said that a prison cell, a single person, designed for a single person, should or must not measure or should not measure less than 6 square meters, and multi-occupancy cells should offer the living space of at least 4 square meters per person. The CPT tried also to suggest a more progressive standard, but nevertheless, let's leave it there for a moment. So the CPT also emphasized in its document that, in fact, whilst, of course, living space is a weighty factor, there must be other factors taken into account, and also created an annex listing those factors which should be taken into account, together with the living space. The court, anyway, opted for basing its assessment about the compliance with Article 3, of conditions of detention with Article 3, just on the square meters. Of course, one might ask oneself, why is so? Why square meters? Why this is the most important thing? Well, the best answer I can provide is that this is the only quantifiable, or the sort of factor. It's the easiest thing to calculate. It's not that easy, I must assure you, because first you must make sure that you're not counting in the toilet. Yeah, and then of course there is this discussion. Yeah, what about furniture? Does furniture matter or not? The CPT said no, furniture doesn't matter. So if you can't really move there because there's so much furniture, but overall the space is fine, there is no problem. But you can't really move there. But it doesn't matter because, interesting, really. But that's how things stand. And then for the rest, well, the CPT listed such factors as, let's say, hygiene. Well, try and quantify hygiene. Go and assess. You haven't seen it. You haven't smelled it. How can you possibly assess it? Ventilation, same. Yeah? Well, privacy, the partitioning of the toilets must be up to the ceiling. Well, yeah, and what if there's still 20 centimeters missing? Without having seen the place, how can you say for sure? And so on and so forth. So you have quite a lot of things there. But still, this is the basis for the case law. The court, well, some people say that the court disagreed with the CPT. I think that's profoundly wrong. I think the court explained very well in Mursic that the CPT and the court had just different functions. And if the CPT recommends the minimum space of 4 square meters, it doesn't mean that the CPT says that everything below 4 square meters is automatically a violation of Article 3. The CPT never said that, and it couldn't, because it has always been careful not to substitute the court. CPT has always used conditional language when talking about ill treatment, saying that something might amount to ill treatment, or might well amount. Could be considered, but never said this is, because this is violation of Article 3. This is only for the court to say, never for the CPT. That was respected. But still, the court more or less agreed with the CPT that if you assure the 4 square meters, then the likelihood of actually violating Article 3 is diminished, because other factors will probably be better also, because the smaller the space, the more problems. It's true. That is correct. So it's not only because it's quantifiable, as I said. I must also correct myself. It's also because certainly when there's overcrowding, it means that everything else afforded to prisoners is shrunk. So it's also a factor. Anyway, the court said, well, there is a strong presumption of violation if it's between 2 and 3 square meters. There is a weaker presumption of violation. It should be coupled with other negative factors if it's between 3 and 4 square meters. The court more or less said that it's straight away a violation if it's below 2 meters, but that is, not so likely to emerge very often, even though there are still countries which do not offer even that in the European space, so to say. But then there is an open question, well, and if it's more than 4 square meters, do we have no problem under Article 3? We might. We often find them. Then what has happened, and that I alluded to this earlier, when I was talking about subsidiarity. This is where I think subsidiarity is not simply something that should be factored in. This is absolutely crucial because it's for the domestic authorities to ensure that things are okay there. And it's for the domestic authorities to assess the complaints coming from persons, from places of deprivation of liberty. But in some domestic legal systems, there is still no effective remedy to be exhausted for conditions of detention, meaning that applicants go directly to the court, to the European Court of Human Rights in Strasbourg. And, well, when was the last time the European Court of Human Rights carried out a fact-finding mission to see conditions of detention? I think it was Ukraine 2006, if memory serves, but might be wrong. But long time ago. It's still in the convention. The court can do that. Well, can it? Yes, but the power is there. The court is placed in a situation of a first instance court. Well, how does it respond? It responds in accordance with the case law I already mentioned, not only Mursic, but also still Ananiev and so on. So basically, when an applicant describes bad conditions of detention, makes a prima facie case, then it's for the state to prove that, in fact, this is not exactly so. And if there is a systemic problem, then the state would rarely be in a position to do so. So essentially, the court is overwhelmed with this kind of applications. It's a huge, constant flow of applications. Ukraine and Romania being the leading countries because they still, well, Ukraine has, so far the court hasn't found that Ukraine had any effective remedy for bad conditions of detention. For Romania, I think there is already the compensatory remedy, but there isn't a preventive remedy yet. It might emerge, but so far, not really. Anyway, this is a huge number of cases. They are processed by the European Court of Human Rights in a very expedited manner, which is called, we are using the internal language, they are fast-tracked. You certainly noticed in the HUDOC database this kind of judgments in the table format. So basically you have standard text of 1, 2 pages to 3 pages maybe. And then the individual circumstances of each applicant, they are inserted in a table. And then there is an award. And we have every month this kind of judgments in dozens of cases, finding a violation of Article 3. Well, Article 3, again, as I said, it's terrible to banalize Article 3. It's terrible to see violations of Article 3 as something sort of that goes without saying, but that's where we are, unfortunately. So hopefully this might change at some point. But of course, this also asks a question: how well are we equipped to deal with systemic structural issues by just applying Article 3? Also heavily relying on presumptions, presumption on presumption? Well, I leave this question open, so to say. But of course, Article 3 remains the bedrock of the system, and therefore, hopefully, it will remain such. What is interesting is that, as you have already heard today, again, I refer to Judge Yücsel's presentation, Article 3 can manifest itself in situations which are quite far from the contexts that I've described, police treatment or prison conditions. We have domestic violence. There can be, let's say, medical malpractice cases where Article 3 is at least discussed and, is it we versus Slovakia, the case of involuntary sterilization of a Roma woman in Slovakia, where Article 3 was found, and a similar but different case, YP versus Russia, where somehow it wasn't found. Then we have questions of, let's say, related to riot control by the police. And then what the court often assesses is the proportionality of the use of force. And on the face of it, the whole idea that the court should be dealing with proportionality doesn't, for me, it doesn't go very well together, again, with the absolute nature and so on. So I'm even wondering whether Article 3 is the right tool to do that. But this is such a well-established line of case law that is very difficult to, I mean, this is already there. Basically part of our acquis, so to say. But it is there. As regards the notions of torture, inhuman and degrading treatment or punishment, we are very much, I would say, in a situation of uncertainty, because even though there are many reasons why the court should be differentiating these notions in its judgments, there are difficulties doing that. For example, there is an open question whether inhuman treatment can always be considered to be also degrading or not. It's true that not all degrading treatment is necessarily inhuman if there is no violence, suffering, and so on, pain, whatever attached to it. But when there is, when it is inhuman, are there cases when it is not degrading or not? I've heard different views about this. Just think. I'm not ready to give you a clear answer about this. And then again, sometimes I'm asking myself, is it so necessary to make this distinction? Again, the CPT for operational reasons tends to use the term which doesn't even appear in Article 3, ill treatment, which is the umbrella notion for everything that is contained in Article 3. It's very good for operational purposes, very good. But for the court, one wonders, also given the fact that the notion of torture, unlike the notion, and the notion of ill treatment, let's say, in general international law, they have their own meanings, and the obligations that the states have concerning torture, they are not identical to obligations concerning other forms of ill treatment. If you compare the Article 1 and subsequent articles of the 1984 UN Convention against torture with Article 16 of the same convention and so on, you will understand that, I mean, these are not exactly the same things. But when you need to make this distinction, when you don't, well, that's again an open question. I still have about 5 minutes, but I'll stop here. Because I think the topic is, as you can see, very, very vast. Unfortunately, I cannot see any positive signs that this topic might become obsolete, less popular, less important in any foreseeable future. But let's, of course, let it not discourage us from acting accordingly. Thank you very much for your attention.
Thank you very much for your interesting presentation and for your insights. And I know that you had a pretty difficult job because it was the last presentation of this conference, but I'm completely sure that you managed to keep the attention of everyone because this is a very important topic and unfortunately also topical. We have received a lot of questions, but I would like to summarize it. So we would be grateful if you could elaborate a little bit on this. And actually, towards the end, but also during the presentation, you have referred to the distinction between torture, the notion of torture, inhuman treatment and degrading treatment. So first of all, I would like to ask whether, what do you think, whether in light of the living instrument doctrine, is it possible that the exact behaviors that are currently categorized, let's say, as degrading treatment or inhuman treatment, whether they could later become torture when the threshold of the severity changes, let's say that it becomes higher.
Thank you very much. Well, I think thanks for the question, and I think the judgment in Selmuni answers exactly this. Yes, the answer, in short, the answer is yes, of course it can. The question is how likely it is that it's going to happen in the foreseeable future. I think for the topic so far, if not, it's not exhausted, but the definitions are there, at least for the classical uses of Article 3. But again, if the expansion of the use of Article 3 continues, and I'm not particularly enthusiastic about expanding Article 3 beyond the traditional context, to be honest with you, I think that is possible. Again, a lot will depend on where our society is. And as regards the living instrument doctrine, we've heard quite a lot about it during last 2 days. Again, dear colleagues, regardless of sort of the school of thought you consider yourself to belong to, whether you are sort of more on the liberal side, on the conservative side, I just need to emphasize, living instrument doctrine is there. It exists. It will continue to exist. There is no going back there. And it's the only way of ensuring that an instrument such as the European Convention on Human Rights is actually effective.
Thank you so much. And if I may, I just would like also to ask you to elaborate a little bit on the point, what is the practical importance of the differentiation between torture, inhuman and degrading treatment when in the judgments the court may found the violation of Article 3 altogether. So where does it come to play whether a behavior is considered as inhuman treatment or degrading treatment or torture?
Thank you. Well, again, thank you for the question, because I think more or less the elements I've already mentioned. The first is about the stigma attached to the notion of torture. If a state is found in breach of its violation of its obligations under Article 3, because its agent subjected somebody to torture, I think that makes this finding more, I would say, grave for the state concerned. And this is, again, yes, it is about individual justice. Yes, it is about remedies. It's all true. But judgments of the European Court of Human Rights, they are declaratory in nature. Declaratory in the sense that, not in the sense that they are not binding legally, they are, but because the sole purpose of the court, the sole question that it actually answers is whether the state has complied with its international obligation or not. So when it declares that the state didn't comply with the obligation not to torture, this is a grave finding. That I think needs to be taken into account. In practical terms, I referred to the 1984 Convention Against Torture, and certainly when it comes to torture, there's an obligation to criminalize it, there's an obligation to cooperate in criminal matters, whereas for ill treatment, for other forms of ill treatment, and there the definition of other forms of ill treatment, of inhuman and degrading treatment or punishment in that convention I mentioned, Article 16, is not so clear cut. It basically depends on it's like, this is something like torture but not quite torture. Then such obligations are not there. But for the European Convention on Human Rights, there isn't a big practical difference. The fact that it's the same prohibition, the fact that it's the same article, it's the same absolute nature of the negative aspect, so to say, at least, I think is extremely important.
Dear Justice, thank you so much for taking the time for answering our questions.
Thank you very much.